Founded in 1909, the NAACP is the nation's oldest and largest civil rights organization. Its members throughout the United States and the world are the premier advocates for civil rights in their communities. The North Carolina Conference of Branches is the largest state conference in the South, the second largest in the country, made up of over 100 adult, youth, and college branches across the state. It is the convener of the more than 150 members of the historic Thousands on Jones Street People's Assembly Coalition, and the North Carolina Conference of Branches is the architect of the Moral Monday Forward Together movement. Yesterday, on the 15th installment of the Moral Monday movement, anticipating that the governor would follow and kowtow to the actions of the extreme and immoral, ultra-regressive Republican majority of the General Assembly, we chose not to have a Moral Monday protest in the state, but to do what the NAACP and the Moral Monday movement has promised, and that is to have a legal strategy to fight against this General Assembly and this action that we believe is constitutionally inconsistent and morally indefensible. And so yesterday, the 15th installment of Moral Monday, on August the 12th, 2013, 48 years after the signing of the Voting Rights Act, nearly 50 years after the March on Washington, and 143 years after the ratification of the 15th Amendment to the U.S. Constitution, which codified into law that the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude, the North Carolina NAACP, on behalf of all of our branches and all of our members, filed a complaint, along with Rosa Neal Eaton, who stood to my left, and other plaintiffs that will be added, including Ms. Carolyn Q. Coleman, a longtime icon of the civil rights movement, and Ms. Mary Perry, who has given her life fighting for the rights of others. Others will be added, and we have filed this suit against the governor of North Carolina in the Middle District Federal Court. This action was filed yesterday, the first of the actions to be filed, at 3:38 p.m. in the Middle District. The legal challenge is filed by the North Carolina NAACP. Counsel will be the strong and knowledgeable North Carolina attorneys Adam Stein and Irvin Joyner. The Advancement Project, and standing here with me is Ms. Penda Hare, a premier national civil rights organization that she leads, and the law firm of Kirkland and Ellis, along with the help and assistance of attorney Jamie Phillips and attorney Al McCrory. It charges that the law violates Section 2 of the Voting Rights Act, which bans voting procedures that discriminate on the basis of race, color, or membership in one of the language minority groups. The suit also challenges the law under the 14th and 15th Amendments of the Constitution, which our counsel will explain in more details in just a moment. Let us be clear, and we ask the media to assist us in this matter. This bill is not about voter ID. It is 57 pages of regressive, unconstitutional acts to rig and manipulate elections through voter suppression. Our complaint and lawsuit will show how this voter suppression bill, in its many eerie elements, revisit the tactics of Jim Crow in the 21st century and are a form of what we have called for months James Crow Esquire tactics, because these suppression tactics have a disproportionate and discriminatory impact, especially on African Americans and other minorities. It is disparate in that regard. The act of this legislature and governor is about race. It is an outright attempt to manipulate voting and the result of voting through suppressing the African American vote and the votes of others that expand the electorate in ways not often favorable to the support of a narrow and extreme political agenda. It is an attempt to undermine fusion coalition political alliances in the New South between African Americans, other minorities, and progressive whites, which is why from Mitchell County in the mountains, that is 99% white, to Martin County in the eastern Black Belt, North Carolinians are outraged by these actions. Our movement was the first to file, as I said, at 3:37 p.m. yesterday, immediately following the shameful, unconstitutional acts of our governor, who with his signature, given authority only by an election of the people, abdicated his sworn promise to sign into law the worst voter suppression of omnibus bill in the nation. He abdicated his sworn promise to uphold the Constitution when he signed this into law. And to add further insult and shame to his act, he chose a 96-second video with false accusations, misrepresentation of what this bill really is and does, and a gross dismissal of the great and storied history of the struggle and sacrifices waged for the right to vote that he and his party are now attempting to suppress. Concerning rights, it took nearly 200 years, Dr. Spearman, to secure and protect the right to vote from the abridgment. And in 96 seconds, this governor gave his pitiful and untruthful rationale for undermining our rights. The governor that has supported and signed some of the most divisive legislation in North Carolina's history called us divisive.
Mercy.
Lord.
He claimed this bill is about voter integrity when he knows it is not about integrity, and his misstatement of the facts questions his political integrity. He claims it is about voter ID when he knows, if he has read it, that it is not just about voter ID. And even though polls don't determine constitutional rights, he claims the polls are with him despite the fact that the PPP polls show that North Carolinians are overwhelmingly against many aspects of this bill.
That's right.
He claims that we use scare tactics when it is clearly documented that he and his band of extremists have used scare tactics about voter fraud that are contrary to facts and evidence.
That's
right.
And he called this measure common sense legislation. We too would call it common, but we consider that one of the synonyms for common is vulgar, lacking sophistication or good taste, unrefined.
All right.
So by that definition, his actions are common, a vulgar misuse of political power designed to manipulate and rig elections.
That's right.
Governor Pat McCrory and the North Carolina legislature are on the wrong side of history.
That's right.
They are committing a crime against democracy
Crime.
and our most sacred constitutional values. This anti-voting rights bill tramples on the blood of our martyrs, desecrates the graves of freedom fighters, and in the 21st century lines up with the extreme racially driven philosophy of interposition and nullification promoted by past political figures like George Wallace and Strom Thurmond. Remember, Strom Thurmond was the only Republican in the United Senate, the only one who voted against the VRA in 1965. This a direct attempt to suppress the civil rights of black people in North Carolina and secure power through manipulation of the electorate are ultimate crimes against democracy. For the governor to sign this horrific bill less than a week after Julius Chambers, one of our civil rights heroes, was laid to rest is dishonorable. A few years ago, the North Carolina General Assembly passed the most race-based redistricting plan we had seen since the 19th century. I would ask the members of the media to remember that U.S. Congressperson who's now bidding for the chair of the Oversight Committee, Patrick McHenry, openly acknowledged in Politico, in the press, that the Republican Party would in fact use race in designing its redistricting plan. Now, this atrocious voter suppression bill the governor has signed, which represents the worst of every voting rights attack in the nation combined in one piece of legislation. It seeks to end same-day registration, limits early voting, ends Sunday voting, unleashes vigilante poll watchers, takes away public financing, disallows 16 and 17-year-olds the ability to pre-register, and mandates a 21st century poll tax in the name of voter ID that is more restrictive than South Carolina and Alabama. As Bob Hall in Democracy in North Carolina, one of our fact advisors and documentaries in this suit, has noted, this is a monster bill when it comes to voter suppression. Our attorneys will explain factually and statistically the data that supports this claim. Finally, it should be noted that after denying Medicaid to 500,000 North Carolinians, unemployment to 170,000 North Carolinians, earned income tax credits to 900,000 black, white, Latino working North Carolinians, changing the tax code of North Carolina to favor the wealthy, attacking public education, attacking public school teachers, attacking women's rights, attacking labor rights, and expanding gun rights. Now, this group of extremists want to manipulate and cheat their way into and hold on to political power. It seems as though, and I hope members of the media catch this historical piece, it seems as though this legislature and the governor view the Supreme Court Shelby decision in the same way the radical racists of the South in the 1800s viewed the removal of the federal troops in 1877. Remember that Senator Apodaca said on that when that decision was made, now that the headache has been removed. He described the Voting Rights Act that was won only after Medgar Evers was shot through the heart in the front of his wife. And Viola Russa, a white woman, was shot with a shotgun blast as she was transporting marchers in the Selma to Montgomery March. And Dr. King was shot through the throat because of his support for equal rights. Apodaca described this measure as a headache. A headache. It is as though they see the Shelby decision like they saw the removal of the Northern troops of the United States, American troops, in 1877. Because immediately after that, Southern legislators began to pass all forms of voter suppression and Jim Crow law. We are not left-leaning groups.
All right. That's right. All right.
Not those of us who are challenging this bill.
All right.
We challenge this bill. We filed this suit because we are civil rights centered groups. We are constitutionally centered groups. We are morally centered groups. And we know that in a democracy, protection of voting rights must be at the center of that democracy, or you do not have a democracy.
That's
Yeah.
right.
Yeah.
The 14th, 15th, and 24th Amendments and Section 2, 3, and 5 of the Voting Rights Act are still the law of the land. Shelby did not change that. We will fight this race-based, immoral, and regressive bill with everything we have, and we know we will be victorious
Right.
because history tells us that truth and justice always win. We won against the slave masters. Women won against those who were patriarchal and did not want them to participate in America. We walked into the courtroom in 1953 and could only count 2 votes on the Supreme Court. But after the truth and after the brilliance of lawyers like those who have gathered here today of different races and different colors, but all committed to the fundamental principles of democracy, got together, we walked in only able to count 2 votes. One Supreme Court justice was a former member of the Ku Klux Klan. But when the dust settled,
When the dust settles.
we walked out with a vote 9-0
Yeah.
and overturned Plessy versus Ferguson.
Yes, sir.
We will not only fight this battle, we will win it.
Yeah.
Penda?
Advancement Project is honored to be part of the legal team representing the North Carolina NAACP and Mrs. Rosanelle Eaton and other plaintiffs to be named in this historic case challenging the most pernicious and discriminatory set of barriers ever enacted in one law. It's important to note that this lawsuit is part of a movement. As Reverend Barber mentioned, led by the North Carolina NAACP, the Forward Together movement has ignited people of goodwill across North Carolina and the United States. The lawsuit will bring the movement into federal court, and the lawsuit will be carried on the shoulders of the movement and will be conducted so as to support the movement. I want to thank our co-counsel, renowned civil rights attorney Adam Stein, Irv Joyner, a distinguished law professor and chair of the NAACP of North Carolina Legal Redress Committee, and the law firm of Kirkland and Ellis that is donating its services pro bono because this case is in the public interest. This lawsuit is brought under Section 2 of the Voting Rights Act, which prohibits race discrimination. The lawsuit claims that the new provision, specifically elimination of same-day registration, which 70% of African Americans, elimination of same-day registration, which African Americans use disproportionately, the cuts in early voting days, including a Sunday day, the new very strict photo ID, which includes ID that students don't have, that many people with driver's licenses don't have, that would be required to vote in person but not absentee. The changes to provisional ballots, so that if you inadvertently end up in the wrong precinct, no part of your ballot will be counted. Even though previously the votes for offices that didn't matter by precinct would be counted. The expansion of challengers, which we know has historically been used for racial discrimination, is also challenged. Our claim is that these provisions individually and collectively will result in a denial, and a totality of the circumstances will show that it will result in less opportunity for African Americans to vote, to have their votes counted, and to elect candidates of their choice. The lawsuit also claims that the legislature acted with racially discriminatory intent when it passed this law. The impact alone, the stark racial impact, is very, very strong evidence of intent. And we will introduce other proof as this case goes forward of the motive of the legislature to discriminate and suppress the votes of African Americans. The finding of intentional discrimination will be important because, as Reverend Barber mentioned, after the Shelby County case, 40 counties in North Carolina are no longer required to obtain pre-approval from the U.S. Department of Justice before changing their voting practices and procedures. And the state is no longer required to obtain pre-approval. We've already heard that counties are moving in a discriminatory way to close polling places and take other actions that would not have been allowed prior to the Shelby decision. So one of the remedies that we are seeking will be to bring North Carolina back into the pre-clearance system, which is a remedy that a court may order when it finds a history of voting violations within the state, which North Carolina certainly exemplifies, and when it finds an intentional discrimination within the jurisdiction. I just want to close by saying that we are enthusiastic about moving forward with this case. We believe it is an extremely strong case, and we believe that we will be able to stop this law, this pernicious law, from being implemented in the state of North Carolina.
I too am privileged to be one of counsel representing the NAACP in this lawsuit. I've been at this business for more than 40 years, and this is the most aggressive piece of discriminatory legislation that I can remember that the legislature's ever passed. It is not only true, as Penda Harris pointed out, that each one of these provisions has an adverse impact on African Americans. For instance, the whole business of early voting, 70% of African Americans who voted in the 2012 election voted early. Right. But they have reduced by a week the number of days that are available for early voting. All the other provisions also have an adverse impact. It's not only true that there's an adverse impact, but the General Assembly knew that. Yes. Opponents of this legislature in the General Assembly who were opposed to this bill stood up and cited chapter and verse, all the statistics, and they knew what they were doing. They knew that they were going to reduce the number of African Americans who would vote in elections in North Carolina. We are here to uphold what the United States did in passing and adopting the 15th Amendment, which is supposed to abolish all distinctions based on race with regard to the vote. And that's what this lawsuit is about, and that's what we'll accomplish.
I am so disappointed in this governor and our legislature. I came to North Carolina having worked in Mississippi and Alabama, where this kind of voter suppression was taking place, thinking that North Carolina was a much more progressive state. And it was for a while, but now I feel as though I'm reliving my life. All of the things that I lived in Mississippi and Alabama, here they are again. This whole notion of voter ID, which the suit is really not mostly about, but the whole notion of voter ID, students that come to the state and, well, that live in the state really, that attend college that is a state-supported college, cannot use that ID that was issued by the college. They will now have to get another ID that's issued by the state. It just doesn't make sense. When we try to encourage our young people to get involved in voting, and we see that now students who were at one time able to register early prior to their 18th birthday will no longer be able to do that. The the early voting that our people have always been involved in, because everybody doesn't have transportation, some people have to work, and so the early voting has yielded 70% of those who are African Americans as voters. And it seems as though that at a time when we should be pleased that people are voting in America.
That's right.
This is not one of the third world countries, but they are voting in America, and we want to suppress that. It just doesn't make sense that we would have a state that has always, since my years in being here, since '79, been progressive, has now turned back the hands of time. The clock will no longer move forward for North Carolina. And just one last thing. The governor has talked, I just heard him on the radio, talking about an identification that was needed to purchase certain medications that are used to make drugs, and he compares that to people needing an ID in order to vote. If he doesn't see the difference between those, then North Carolina is really in serious trouble.
Really?
Good morning to everyone. Good morning. Good to see you here. Today I'm here as a 92-year-old lady. Been involved in NAACP for over 60 years, among some of the older ones that hasn't gone on before me. As Sister Coleman said, that this is a scheme thing that's made up to do this. All of the people that are here in North Carolina should get involved and learn some things about this legislature, the governor, and all their plans. Well, the voting bill it was designed for all of us to take a part and be active in doing so. It was a desire to make it harder by having all these attributes and things against us. And here I am at 92, going through this struggle that we had years ago with Martin Luther King, trying to uplift society and make the world better. American is American. We are people of intelligence. We have moral, and the ones that doesn't have it needs it. The voting process must be understood alongside Republicans' effort to eliminate, rather cut, early voting, outlaw Sunday voting, and banning same-day registration, alongside the effort to keep college students from voting by inflicting a heavy financial penalty on the parents. And if they attempt to vote, they will take away all the extra money that they would get out of federal government to pay these dues their parents would. We need more voting.
That's right.
Instead of less.
That's right.
We encourage and instill in children at age of 16, 17 years old to get out and vote. That's your rights.
That's right.
The Constitution says that. And our rights are being taken away from us. And we should not stand idle. I'm proud to be a plaintiff on this bill because it is absolutely wrong. And we cost a lot of money to do the poll taxes. Everything they can do to lower us down and decrease us is what they are trying to do. And I don't understand why people in the world in the years of 2000 would have an idea of trying to do things of that kind. When Jesus called us, he called us to be citizens, to be on one accord and try and strive to live in this world and prepare ourselves for the next world. But as we are going on, we're just preparing ourselves for anything that comes by. Who would ever think or appreciate that people would try to pull down little children and keep them from learning? Do away with history books so they can't learn. That is a disgrace.
Speak, mother.
And we just need to really pray that these representatives will humble themselves and pray that the Lord will soften their hearts.
Amen.
Because their hearts are hard
That's right.
by cutting off all these things and by cutting and reducing the total hours that we could go out and vote. You cannot make hours. The hours that we got here today are going on and on and on. We can't stop them. And if you stop the privilege of a day, Sunday's voting, or any day that you cut out, it will decrease the amount. They know that.
That's right. That's
They are just evil.
Yes.
And that is wrong, disgraceful,
Yes. Yes.
disgusting, and it needs to be a change in that way that we are going. And I feel like that we need this bill corrected. We need to let them know that they are people that the Lord made also,
That's right.
and they need to change their way of doing things.
Yes.
Not just because they have a privilege to do it or have the most votes, but just have a heart.
That's right. That's right.
The Lord said, have a heart like thine. If
Amen.
we can't make the hearts, we can pray to the Lord. And the Lord has always answered our prayers, and we feel like that He will continue to do so. May God bless each of them.
Amen. Amen.
Thank you so very much.
Amen, mother. Amen. Amen. Amen.
Good morning.
Good morning.
You know, I'm tired of fighting. I've been fighting Jim Crow as long as I started at the age of 16, really. And I've been fighting ever since. Mr. Stein, I want to thank you because I don't know if you remember
I do.
when you came to Vaden Whitley.
Yeah.
Adam Stein and Chambers came and fought a case with us with the school system. So I've been fighting this system a long time. I worked in the General Assembly for 18 years. And I used to hear the Republicans say, when we take over, they said, when we take over, and I heard them say this. I won't call the name, but I'll say that I hear them say, when we take over, we're going to do this and so. And we're going to take over. That's what they said. And they're doing just what they said. You know, Miss Ruth Morgan, a dear friend of mine, who's deceased now, she lived to be 100 years old. She was the first black to register and vote in the town of Wendell. She had to say the preamble to the Constitution. She had to write it. And the person that gave it to her couldn't even read and write it. So, you know, and this trying to keep people from voting, we should be trying to encourage people to vote.
That's right. That's right.
Encourage our young people to get involved in the political process. And that's what I've been trying to do. But what's happening now, you're discouraging them. You're saying that we don't want you to be involved, especially people of color. But I'm going to fight, as Ms. Coleman said, till hell freezes over. I'm not going to give up. I'm going to do everything I can to fight this evil that's suppressing us. Because it's just wrong what they are doing, and they know it's wrong.
That's right.
Trying to keep our people from. We had more people to vote this time in this past election than we've had to vote before. And now you're going to say that you're going to cut out early voting. Now, I was told that the early voting going only have one place to go to vote, and that was going to be the Board of Election. If that's true, what's going to happen to look in Raleigh? Where are people going to park?
That's right. That's right.
How are they going to get there?
Teach us. Teach
You are not trying to make it easier for people. You're trying to make it harder. And you're trying to keep people from voting. And I am going to do everything within my power. I'm 83 years old, yes. And I'm going to do everything within my power. I have a group of young people that I work with today, every day. And I'm telling them, and I'm telling our people in my church and everywhere I can, get ready, because what they're doing, they're hurting themselves because people are not crazy.
That's
They
right.
can see, they understand what's happening.
That's right.
They understand that you're trying to keep us from getting to the poll. They want to keep themselves in power. To do what? To try to purge us, to kill us, and make us suffer. And we are tired, we've been bondage long enough, and we are coming out. We are not going to have it. We're going to fight, fight, fight.
Any questions? Yes, sir.
You talked about the totality of the litigation against the state on this. You think is very strong, but would you pick out one particular provision in the law that you're challenging that you would say this is, in my view, a slam dunk?
They're all, the case against all of them is strong, and the evidence is laid out in the complaint, and more evidence will be offered as the case moves forward. But I think our claim is that each of these individual challenge provisions is illegal, discriminatory, and will have a adverse result on African Americans. And collectively, when you add all of these things up, when you add up that you have to now show an ID that many people don't have, then you don't have as many days to vote. If you didn't get registered before the deadline, you can't do same-day registration. Then you might end up in the wrong polling place, which happens more frequently with African Americans. Then your vote won't be counted that way. When you add up all of those statistics and overlay them, the impact is going to be horrendous.
Attorney Harris, remember too that when we did an examination of the impact of the redistricting last year, we found that just in the primary, thousands of people literally went to the wrong precinct because of the redistricting plan that they implemented that split so many precincts. So they've actually set up a double whammy. Yeah, they've set up, they've set up a whammy, the double whammy, where on one hand, the redistricting plan is flawed, and it has created an overwhelming number of people who find themselves at the wrong precinct. Now they're saying if you happen to end up there, on top of that, your votes won't be counted, which is a change in the law in North Carolina. Ms. Coleman?
Yeah, I just want to add, in Guilford County, not only did we have the problem that you've talked about, we ended up having to sue the state there because they left out 43,000 citizens who were not included in a district to vote last year. So they did everything so hurriedly, it was half done.
Operation Chaos.
Operation fail, Al says.
Chaos.
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 No, that's what they want.
Yes, yes, ma'am?
What's your timeline? How long do you think this will take?
Well, our goal is to have these provisions enjoined before they impact the next set of elections in the state, so certainly before 2014.
Any federal people be involved?
But we don't know. We understand that the Department of Justice is looking at it, and it certainly would be a strong case if they decided to move forward in North Carolina.
There's another part of the case that we filed, and that is that we say that when you decide the case and enjoin the defendants from enforcing any of these provisions, that you should also then return North Carolina under Section 3 of the Voting Rights Act, what's called the bail-in provision, so that they will need to get pre-clearance going forward, say for 10 years, since they have, in this instance, shown their willingness to disobey the Constitution and Section 2 of the Voting Rights Act.
Yes, sir.
Reverend Barber, per the elimination of souls to the polls, Sunday voting, one of the sponsors of that, when asked, well, why do you want to eliminate that? He said, quote, "We just don't think people should be voting on Sunday."
Right.
What's your reaction to that?
Well, he also said, and I think we have it on tape, where he suggested as well that blacks had 6 other days. Again, that shows this deep disregard and disrespect for history. It was on Sunday, after church, that people prayed and then marched and began to go across the Edmonds Pettus Bridge in Selma and were beat. It's called Bloody Sunday. And so in fact, to vote on Sunday is to honor those who sought to, if you will, resurrect America from the ugliness of sin, ugliness of segregation and discrimination. You know, Sunday for us is the day of resurrection. But what's also so hypocritical about that legislature making that comment is that we have seen them over the past year on Sunday night roll out budgets that hurt all of North Carolina. So it seems to suggest, if I might use the language of Sister O'Neill, since she's the mama in this crowd, that it's all right to do evil on Sunday, but it's not all right to do righteousness on Sunday. And that sounds a little bit about like the Pharisees of the Bible, if I might say as a theologian. It is totally contradictory. And it exposes why these premeditated acts are being engaged in. It is because of their fear of the New South, their fear of the power of the African American vote, and their fear of the power of that vote voting in full measure when it joins with progressive whites and Latinos and others that can literally make a difference and change the South. That's what's really going on. Gary?
I'm sorry, this litigation could take a year, it could take 2 years before it gets finally resolved. Are you concerned that a delay will hamper your Moral Monday efforts going forward?
You know, the reality with Moral Monday, Gary, and started with 17, ended with thousands. Asheville, 10,000 people. Right after Raleigh with over 10,000 people. Asheville in the mountains, predominantly white, led by the NAACP, but you saw North Carolinians, fed up. We go to Manio next week, they're already organizing. We go to Charlotte, they're organizing. We went to Mitchell County, 99% white, 87% Republican, packed church right across the street from Representative Heiss, who supported much of this legislation. And there in that church, Republicans, Democrats, Independents, a few black people and white folks sung, "Blessed be the tie that binds." And we talked about the tie that binds us when we stand for public education, the tie that binds us when we stand against those who would hurt the unemployed, the tie that binds us when we stand against those who who try to take voting rights. The passion and the power of this movement is not going to die because people understand how historic it is and how important it is. In fact, this legislature, like all extremists, have overreached. They always underestimate the resolve, not just of black people, but of people of conscience and people who operate by a deep moral compass and who are concerned deeply about the Constitution. No, there will be no weakening of the movement. In fact, they will strengthen, and the lawyers understand this. And then we don't know whether it will be a year or so. We're yet to see. You heard Adam talk about bail-in. We've got a lot of other pieces. The Justice Department, we believe everybody ought to come into this because this is not just an attack on North Carolina. Because they let this pass, it signals to every other state that America says, do what you want to now to deny people their 15th Amendment rights. We don't believe, we are not of those who shrink back. We are not those who believe that America has lost its soul to that level. Some may have, but we believe the heart of America is still good. Our democracy is still something honored and to be held on to, and Americans will fight for it. And you even see that, Gary, in the PPP polls, because while the governor claims the polls are with him, and while constitutional rights should never be based on polls, look at those poll numbers. It says that the majority of North Carolinians are against him cutting early voting, against them undermining same-day registration, because there is something good at the core and the center of most people who look at these things through a moral and a constitutional lens. So no, there will be no dissipation of our movement. It will only grow.